Well, let's begin with the latest ruling on the National Defense Authorization Act, or NDAA. A federal appeals court ruled yesterday that the U.S. government can, for now, indefinitely detain anyone. As most of you know, this is a case that we've been following very closely since it was signed on New Year's Eve after President Obama said he wouldn't sign it. Yesterday's ruling effectively overturns the ruling by U.S. District Court Judge Forrest to permanently block the controversial provisions in NDAA on the grounds that they violated both protections by the First Amendment and Fifth, due process. A few months ago, I sat down with one of the plaintiffs in the case, Hedges v. Obama. Here's Chris Hedges himself breaking down the two sections of the NDAA that the lawsuit focuses on, sections 1021 and 1022.
Which, in essence, allows the executive branch to strip an American citizen of their constitutional rights to due process and to hold them in military facilities. That's what we're questioning. A very, very tiny part of the bill, which I think, you don't have to be a legal scholar to determine is clearly unconstitutional. I mean, the egregious violation of constitutional rights is really, undeniable.
So we want to break down exactly what yesterday's ruling means for the NDAA, for journalists, and for the country itself. I'm joined now by Carl Mayer, attorney for the Mayer Law Group. Carl, what's the bigger takeaway here from this latest ruling on NDAA?
Thanks, Christine. Thanks for having me on. The import of this ruling is more a procedural one than anything else. This is an appeals court, the Second Circuit Court of Appeals in Manhattan, and they ruled to put a stay on Judge Forrest's permanent injunction. But it's only a stay pending an appeal, meaning that the Second Circuit is going to hear the merits of this case and whether this law, the NDAA, is unconstitutional. And they'll hear it on an expedited basis, which was part of their order yesterday, which was, I think, a victory for our side, because these appeals can take a year or 2 years sometimes. But they set a briefing schedule that will allow them to rule on this probably within the next 3 to 4 months, either the end of the year, beginning of next year. It was not a victory to have them put a stay on, and we thought that they made a mistake because by staying Judge Forrest's very carefully crafted order, we think they are not giving due regard to Americans' First Amendment rights, free speech rights, and equal protection rights. Instead, what they're doing.
I was going to say, let me go through, just for our viewers who haven't read this, I want to go through some of the reasons listed for the stay. First, the government clarifies unequivocally that journalists and activists are in no danger of being detained by the U.S. military. The statute does not affect the existing rights of U.S. citizens or others arrested in the U.S. It also says the language on the injunction appears to go beyond NDAA itself to limit the government's authority under the authorization for the use of military force. So talk a little bit about these reasons given by this three-judge panel for why this stay was okay and necessary.
Sure. And again, this was only this was a two-page order. The Second Circuit has not considered this on the merits. They simply issued a procedural stay, and it probably would be a panel of completely different judges that will hear the merits of this case. But as to the reasons, the first reason that they say is that the plaintiffs themselves, according to the government, are in no danger of detention. Well, Judge Forrest addressed that in her opinion below, and she said, frankly, the government, when it was asked on the record, can you assure these plaintiffs that who are journalists and activists, that they will not be detained under the NDAA, they will not be put in military prisons? The government counselors, government lawyers repeatedly said, we cannot offer those assurances. We cannot offer those assurances. And that was the only evidence that the government put in their case. The government later shifted in their briefs, in the briefs that they put into the Second Circuit, and in those briefs they said, the plaintiffs are in no danger of being incarcerated by the military. But that doesn't constitute evidence in a court of law, and we can't believe the government's position. And Judge Forrest herself noted in her opinion that the government had switched their position a couple times in front of her. They tried to hedge and say maybe some of the plaintiffs are subject to detention, some aren't. So that reason we don't agree with, and that's what we'll be arguing in our papers before the Second Circuit when they hear this appeal shortly. The second protected under the NDAA, by the language of the NDAA. Judge Forrest also addressed that in her opinion and said, the NDAA doesn't say anything of the kind. It just says that existing law applies. And the problem is that there's no reference to what existing law means, and it has to be clarified, and that's what Judge Forrest did.
Yesterday's permanent stay was issued, as you mentioned, by a three-judge panel of the U.S. Court of Appeals.
Just a correction. It's not a permanent stay. It's a stay pending an appeal.
Okay, a lot of what I was reading, that it was calling it a permanent stay, but the stay pending the appeal, and it was issued by this three-judge panel. One of those judges granted an emergency stay a couple weeks ago. I guess I want to know from you, Carl, a little bit about the timing. I mean, what is the emergency here?
Well, from our perspective, the emergency is that at any point in time, as long as there is this stay and as long as the NDAA is in effect, at any point in time, our plaintiffs or any other journalists or activists could be taken to a military prison and detained without counsel and without right to a trial by jury at any time of the day or night. That's the emergency that we have, and we think it violates the First Amendment and the Fifth Amendment of the United States Constitution. The government is saying that their emergency is that they are impeded, the president is impeded and cannot conduct the war effort as long as Judge Forrest's order is in place and the NDAA doesn't exist. We say that's nonsense because the president has all sorts of powers at his disposal to go after terrorists, statute after statute after statute, regulation after regulation after regulation that have been passed and implemented since 9/11. So the government has yet to make its case in any evidence. They haven't put in one witness, not one document, not one scrap of evidence, just their briefs, that's all they've put in, to show why they need this emergency stay, and we don't agree with it.
And I know one of the biggest problems the plaintiffs say they have is the nebulous language. Judge Forrest called it unconstitutionally vague. We're talking about the targeting of people who, quote, substantially support terrorists or are, quote, associated forces. Chris Hedges, for example, argues he could be a target because he's interviewed some alleged terrorists as part of his job. Why can't these provisions just be removed?
Well, that is another option, and we hope that during the pendency of this appeal, the Congress will come to their senses and honor the Constitution, honor the First Amendment principles of free speech and the Fifth Amendment principles of due process, and repeal these provisions of the NDAA and make it very clear what the government can do and what it can't do. Because right now, there's a sword of Damocles hanging over all journalists, all activists, in fact, all citizens in this country who might have anything to say about terrorism, the Middle Eastern situation. Really, they don't know whether they could be detained or not and what conduct would cause the government to detain them. And this is precisely the problem.
Carl, just one more question for you. I mean, this is one criticism coming out of this ruling, and that is that, you know, this is an example of the government not liking the results of one court. So another court, in this case the Court of Appeals, just steps in. I mean, is this just part of the way the justice system in America works? Or, you know, is this the president using special powers? What do you make of all this? Well,
litigants have a right to appeal their cases. This Second Circuit Court of Appeals is the last stop before the Supreme Court. This case might well wind up in the Supreme Court, but nonetheless, President Obama, who had spoken out against the NDAA and detaining American citizens, he said clearly, it's 200 years of American history has one governing principle: the military doesn't patrol our streets. This law allows the military to patrol our streets. And it should, as Judge Forrest indicated in a very strong opinion, it should never have been passed and has now been struck down by the district court. I think the Obama administration is showing themselves to be on the wrong side of civil rights here. They shouldn't have gone forward with this appeal. They shouldn't have done it on an emergency basis. They indicated, in fact, to Judge Forrest it was such an emergency that if she didn't grant them a stay, they would go to the Second Circuit, which is what they did. I think that was slightly inappropriate because it had almost the effect of sort of intimidating a federal district court judge. They now have gotten their stay, but they cannot escape, I think, from the merits, and we think we're going to present a very powerful appeal.
All right. We did think it was an important update to give because a whole lot of viewers follow this closely, and we appreciate having you on to break this down. Carl Meyer, attorney for the Mayer Law Group. Thanks so much.
Thank you, Christine.